So, Mr. Valentine, here for confirmation of that jury trial that's scheduled for the 18th and 19th. So the question is to everybody, I see that you filed several motions, had a time to kind of look at generally, looks like there are some motions about evidence in there that need to be heard at the time we start trial. So we'll do that. Otherwise, all the rest, we'll just hear the day of trial, get that figured out. Are you prepared to go to trial on the 18th and 19th?
No, I'm still waiting for some documents from the Office of Assigned Counsel, a request for stipulated facts, the case transcripts, bonds, and bar numbers of the individuals of the case.
Okay, let me ask you, how is that going to impact your defense at trial?
All right, guys, we're jumping straight into a tense courtroom moment where the judge is locking in trial logistics. Mr. Valentine is back before the court for confirmation of a jury trial set for the 18th and 19th. The judge immediately addresses the stack of motions already filed, noting that some evidentiary issues will be handled during the trial itself rather than dragged out in pretrial arguments. The message is clear and firm. This courtroom is moving forward. The judge wants efficiency, not endless procedural back and forth. Now the spotlight shifts hard onto preparedness. The defendant is directly asked if he is ready to proceed. What starts as a simple scheduling confirmation quickly exposes deeper friction, legal readiness, understanding of procedure, and whether this case is actually prepared to hit trial on time without disruption or delay.
Because I need to go over the documents and the case transcripts, things that I've submitted and things that have been done by government officials in the case previously.
But what does it have to do with your defending against the charge? That's what I'm trying to figure out. So that may be something that you want to, I'm not sure what you want to do with that. If you're thinking that there's governmental misconduct or ineffective assistance in counsel, or you want to make a bar complaint or something.
All of the above.
Yeah, that doesn't impact the issues as to bringing a trial forth on the charges.
Well, it does, because I'm going against the state, and the state's governmental misconduct is a direct effect of how the case is turning out.
Okay, so let's put that aside. Would you be ready to present your defense?
Once I get those documents, I will be able to.
Okay, all right. And so those documents would be transcripts of the court records.
Yes.
And
a request for stipulated facts.
I don't know what that is. Stipulated facts. What do you mean by that?
I made a judicial notice over the facts of the case, of what I was trying to get straight with prosecution, and none of those questions were answered as far as the legal terminology that we're using.
So what they're charging you with? Or what is it you want from the prosecutor?
There's a judicial notice I made. I'll have to see the transcripts to see exactly what I put on my judicial notice, but the terminology used by the court officials are misguiding. So I was trying to get an understanding with prosecution of what exactly.
Things escalate fast as the defendant admits he is not ready for trial. He claims he is still waiting on multiple documents from assigned counsel's office, including transcripts, stipulated facts, bonds, and records tied to individuals involved in the case. The courtroom tone shifts immediately. Now the judge is digging in, questioning how any of this actually impacts the core defense at trial. The judge's questioning is sharp and direct, cutting through the long list of requests. The defendant insists these materials are necessary to understand prior filings, government conduct, and the history of the case. But the court isn't buying delay tactics. The judge redirects the focus back to reality. The purpose of trial is to defend against charges, not endlessly review administrative paperwork or chase every document ever created in the case file.
I'm trying to figure that out.
For example, like the state of Washington and Washington State being two different things.
Okay, they're not. I see that you may think they are, but effectively in law, they're not. It's not an issue here. Let me just kind of look at some of the things you filed and see. Okay, so, all right, transcript of past hearings. Something from the prosecutor that I can't quite figure out. You want information about the previous attorneys that may have represented you for a short
Yeah, I
time?
wanted the communication between previous counsel and the prosecution, the case transcripts, and the bonds on record and oaths of office.
Okay, of the oaths of office of the prosecutor. Who?
You and the prosecutor, and for the attorneys that I previously had.
Well, for me, you could just go to the auditor, state auditor, or the city or the county auditor. They have everything there. Prosecutors, you can always ask the prosecuting attorney's office.
The office of assigned counsel can't provide me with that.
You can certainly, ask them too. Ask them for their people what they have. I can't say.
Okay, yeah. I haven't got a response yet. I've sent the email. I've called them and sent the email.
All right. So again, you're representing yourself. Still trying to figure out how those are impediments to.
Because even though I'm representing myself, the court is still obligated to provide legal assistance.
The court isn't supposed to provide legal assistance to either side of you. We're supposed to make sure things are done right and fairly. I can't assist you in your trial.
The tension rises as the judge directly challenges the defendant's logic. The court makes it clear that claims of governmental misconduct or disputes over legal wording do not automatically affect the actual defense against criminal charges. The judge questions whether the defendant is truly preparing for trial or getting lost in procedural arguments that don't change the core issues. The defendant argues that he needs transcripts and judicial clarification because legal terminology has been misused. He even attempts to compare naming conventions like State of Washington versus Washington State. But the judge shuts it down firmly, emphasizing that confusion over language is exactly why legal systems exist with defined procedures. Court is not the place to reinterpret legal definitions. It is where evidence and charges are tested under established law.
Would be wrong because I can't assist the state either in their trial.
Don't I have a constitutional right to counsel?
You do, and we did appoint Thurston County Public Defense at one point.
So yes, they are appointed to provide legal assistance for me.
Yeah, and so
when I put in my motion, I said that I didn't want to be represented, but I still wished to have legal assistance.
Yeah,
I just don't want anyone speaking for me.
So you want standby counsel is what we would generally call it. Someone who would pretty much sit in the audience, and if you wanted to step back and ask a question of them, you could ask a question of them. A lawyer from Thurston County Public Defense. That's pretty much the utmost of what a standby counsel does. Is that what you're asking for? Because
I'm asking for legal assistance. It's my understanding that I have a constitutional right to counsel.
Sure.
And so I'm asking that the state in some manner provide me with someone who will assist me with my legal affairs. I don't want to be represented or deceived into taking someone else's opinion of how to handle things.
Well, you don't get to kind of pick and choose how it's done. We've appointed counsel at one point, and you didn't want to do that. I could potentially, and I can't speak for the Office of Assigned Counsel. You know, they're the executive branch government. I don't run their office. I simply find if someone is indigent or qualifies for public defense and say, yes, they can have one, and then that agency takes over. But at this stage, so
when I was made pro se, that is what Judge Brent Buckley had discussed. He said that I wouldn't have counsel represent me, but that I would.
The defendant continues pressing forward, claiming confusion in judicial notice filings and insisting earlier questions submitted to the prosecution were never properly answered. He argues that legal terminology used in the case is misleading and needs clarification through transcripts. The discussion briefly drifts into technical naming arguments, but the judge immediately dismisses it as irrelevant. The courtroom stays controlled and focused. The judge reiterates that misunderstanding terminology does not erase charges or change the structure of trial. Instead, the legal process relies on facts and evidence, not debates over wording. The defendant's attempt to challenge the system through language interpretation is treated as a distraction. something pulling attention away from the actual criminal issues the court is required to resolve.
Didn't know
As
that.
far as I knew, that's what was going on.
All right, have you talked then? I'm kind of wondering why someone's on here. All right, so since that you need to, have you had contact with that person since
Yes,
that
it's someone with the
appointment?
last name Thomas. I don't have it written down, but yeah, I've called and sent him some emails. I got him from the supervisor.
Mr. O'Connor?
Yeah, Mr. O'Connor,
Okay.
yes. He told me
All
someone, I think Alex Thomas or something like that,
Okay.
was someone he referred me to, and I've contacted them, but I haven't got a response back from them.
And when was that?
This was just before I got out of jail, so
Just the end of last month?
yeah.
Somewhere around there.
Yeah.
Okay, or beginning. All right, well, so we're like 10 days to trial. You haven't talked to the attorney that's public defense has provided for legal assistance. And so is that part of why you're
Yes,
not
ma'am.
ready to go? Okay,
Yeah.
because that makes more.
Now the judge shifts into a practical breakdown of the defendant's document requests. The list includes prior hearing transcripts, communications with former attorneys, and materials from the prosecutor's office. The court explains that many of these records can be obtained through proper channels like the county auditor or directly from the prosecution. The judge is firm. The court does not exist to collect or assemble case files for a defendant. Meanwhile, the defendant insists he has already tried contacting offices through email and phone calls without response. The judge listens but stays structured, reinforcing a key point. Trial preparation cannot be stalled indefinitely due to paperwork requests that should be handled through standard administrative processes outside the courtroom.
Sense to me. All right, well, let me turn to Mr. Abid, who's representing the state on that issue.
State would have no objection to a short set over, Your Honor.
All right, so now just so you understand, you're asking for a continuance. It's a fair request. I would find what we call good cause for that request. But that would put us into an excluded period under the time for trial rules. And we would set another confirmation date, and we would set it, actually we'd set a motion date, confirmation date. Let me look at these motions. Motion date, confirmation date, and a jury date. We'd send those to you in the mail. And if you'd like a text message reminder, we'd send you one of those too. And then going to go on the process. And then at that point, then you contact, I would think you would want to contact Mr. O'Connor's office and be sure that you can hook up with the person you need to and discuss all of this with them and then be back. But we're going to set that motion hearing so that we have everything done. Now, you filed everything. You filed a lot of motions. You've got everything filed. State needs to respond, and then the court will hear